My lords, thank you very much. So, next stop, IA and others, tab 12. And my overarching submission about this is that the decision of this court is more nuanced in many ways than my learned friend has suggested. So the facts you have, the appellants, the applicants in I and others were a husband, wife and 4 children in Gaza. The sponsor was the husband's younger brother. The sponsor had a close relationship with them before leaving, with no finding that they had family life before leaving. That wasn't the basis on which the decision was taken. The sponsor left Gaza for the UK in 2007, and he did so in order to work in the UK. He wasn't fleeing. You see that page 227, paragraph 15. I don't need you to turn it up. He suffers from mental ill health, 228, paragraph 19, but nonetheless is fully employed working for a media company in the UK, earning nearly £4,000 a year. That's an indication of the extent to which his mental ill health was not, as we say, as the Secretary of State certainly said in that case, impacting on his ability to function on a day-to-day basis. He left Gaza when he was well into adulthood. Sponsor had formed and then had a family dissolve in the UK, and the sponsor had continued. The appellant had continued to develop family life. The circumstances of the appellants in Gaza were appalling. That's 227, paragraph 17. Another case where there was high level of sympathy. What the First-tier Tribunal found, and so of course it was hearing an appeal the First-tier Tribunal was hearing an appeal in September 2024, was finding that since the conflict had begun, in other words, in the last 11 months, and that's the context in which we look at recently formed family life, that the sponsor had provided real, effective and committed support to the family. That's page 228, paragraph 22. But expressly, in that case, the First-tier Tribunal held that there had been no dependency. You see that again, paragraph 22 of page 228. It was short. So there's a finding of fact that there was genuine, effective and committed support, but it was short of the family being dependent. Those are the findings made by the First-tier Tribunal. But the finding was that family life had existed since the start of the conflict, so again, less than 12 months. The First-tier Tribunal, as we've seen, dismissed the appeal because it held that the refusal had been disproportionate. You've already been taken there. The Upper Tribunal on appeal upheld the finding about family life and therefore didn't remake it. So in other words, it upheld the finding that there was real effective and committed support, but no dependency. I believe that to be the correct test. You see that at on page 229, paragraph 28. So like the tribunals in this case, the tribunals in that case proceeded on the basis that the correct test was the real effective and committed support test. But unlike the tribunal in this case, unlike the Upper Tribunal in this case, I should say, there was a positive finding that there was real effective and committed support, but no dependency. So that you see, my lords, why that finding hit the sharp edge of the difference between the two tests. This was exactly a case where a finding had been made which would meet one test and would not meet the other. No dependency, but real effective and committed support. There's no comparable finding in the present case by the Upper Tribunal. The first question on appeal, so there were 3 questions on the appeal, as my own friend he showed you. The first one was the correct test for the existence of family life between adults. And you see it, so on page 230, paragraph 38, you see what the Secretary of State had originally argued. And the Secretary of State had originally argued that it was, in order to establish dependency, it was necessary to establish that a person was compelled to rely on, one person was compelled to rely on the other in their daily life. And that test, as we'll see later, but that test is rejected by the Court of Appeal. In fact, the Secretary of State ceases to rely on it in the course of that appeal and changes her position simply to rely on the Garthus test without a gloss. So you can see the battle lines in paragraph 38, but it's important that the Secretary of State originally advanced a higher threshold test and then had drawn back from that. And the court then reviews, from paragraph 42 onwards, reviewed the relevant authorities. Can I just take you to one of those, which is Alvarado? So that's page 235, starting at paragraph 52. That's the judgment's in the bundle as well, but just quickly here, the relevance to IA judgment you see in paragraph 56, or 55 maybe, but so Mr. Alvarado had sisters who could look after. He was significantly cognitively impaired. He'd come to the Netherlands on a visit visa and overstayed. He was being looked after by 4 sisters in the Netherlands. He had a brother in Peru who could look after him. Dutch authorities said because he's got a brother in Peru, the family life test isn't met. And then you see that the Roman numerals in paragraph 55, Dutch authorities had said that was potentially fatal. The Strasbourg court said no, the existence of family life has to be assessed on a case-by-case basis. So the weight to be attached to any element, but in this case, particularly the fact that there is another person who can look after you, is relevant and depends on other facts and specific circumstances in the case. And so you couldn't derive from any decisions that exclusive dependency was always required. And at times in Malone Friend's submissions this morning, it seemed as if he was seeking to revive that test of exclusive dependency, or the test the Secretary of State had abandoned, which was that it's necessary to, or that a person is compelled to rely on another for assistance in day-to-day life. That's simply not a test which Strasbourg has imposed. Just when the court went on to, this court went on to consider domestic authorities, and you see what it says about Bioku Betts, which my Lord Justice Baker asked about. So that's referred to in paragraph 60, so page 238, paragraph 69 and 70. It's referred to later on for the question of jurisdiction, but on family life, it's there in 69 and 70. But over the page, there's reference to, on page 239, paragraph 75 to 77.
Well, can I just go back on what... So
sorry, my Lord, yes.
In Bioku Betts, on this point, does the formulation, how does the formulation there?
So additional...
Lord Brown, is it Lord Brown? Yes, adopting what was said in Mokrani. How does that relate to where we are now?
It's the same as it's a very slightly different worded, but it's substantially exactly the same as the Kamari test. So what the Court of Appeal held was that various decisions of this, so Garthus wasn't quoted in Bioku Betts. Rye, for example, was during Curie and Bioku Betts. Bioku Betts set out the Strasbourg test. So it was on the basis. So the reason why this court was able not to follow authorities like Rye was because of Bioku, for 2 reasons. One, that it concluded that the aim of the Court of Appeal throughout the 20 years since Garthus had been, in fact, to march in step with Strasbourg, and secondly, because of Bioku Betts. But we'd say so that relationships, unless the existence of additional elements of dependence other than normal emotional ties can be proven, and the only difference is other than rather than over and above. But my Lord, does that answer the question?
Yes. Yes. So in other words, the additional elements of dependence test is fully supported by a House of Lords authority.
It's supported by it's supported by House of Lords authority.
Yeah.
Yes. On one view,
yeah.
which seemed to be my friend's view this morning, it's hard to see how that's part of the ratio in Bjork-Betz. Not what Bjork-Betz was about, but that this court proceeded in IA and others on the basis that it did form part of the ratio, and so there we are. But just over the page on page 239, paragraphs 75 to 77, there's a case of Rye. It's a case where a wrong test was set down. The only reason I'm taking to this is that that my learned friend made the submission this morning by reference to paragraph 82 on page 240, that at no point did the domestic courts say that the test should in fact be supplanted by the test of real committed or affected.
Well, what the court says there is at no point did Lady Justice Clark say that.
Exactly, in Mobian judgment. But it's very clear in Rye that is what the court did, and it's following Rye that test has been used and has been used for 9 years in the tribunal. And Rye was an empty clearance case, unlike most of the others. As you can see from the title, most of these are removal or deportation cases. The Rye is an empty clearance case, and that became the test which was used. It's the reason why, in cases like this one and in IA and others, the submission was made in good faith, and tribunals in good faith applied a test which appeared to have been given.
So IA restores the position to what it was in Bjork-Betz. Is that the way to see it? Is that too simplistic?
No, I'm sure that's. By the time of Bjork-Betz, there were two interpretations going on in parallel. There was Bjork-Betz on the one hand, and there was the line of authorities from Cogarthus on the other, where Lord Justice Sedley had read down the Strasbourg test, so Cogarthus in 2003 is the origin of the real effective and committed support test. But it's really only with Rye that was seen as being a restatement of the test rather than this is I'm almost giving evidence here, but just in terms of the way in which the tribunal dealt with these cases, it's post Rye that's been treated as if it were the ultimate test. And so yes, but my lord, I agree that it's right to what I and others has restored the Strasbourg test without gloss.
Yeah.
Which is the way in which the House of Lords in Bjork-Betz also applied the test, and that's without the gloss that was put on by Lord Justice Sedley in Cogarthus in the subsequent case, but also without the gloss that the Secretary of State had at one point suggested, which was a higher test, which was that dependency had to be total dependency. Sorry, where I got to? My lords, yes. So then the Court of Appeal's decision on the legal issue, and you've been taken there as well, 245, starting at paragraph 113. That's where the tribunal's right about the existence of family life. And the conclusion, paragraph 116 on page 246, you've seen this. Correct test is the one enunciated by Kamari and by the House of Lords of Bjork-Betz. So maybe that's the answer to the question. That's what. So Kamari is restating the test that's always been there and had been stated in Bjork-Betz. But just looking again at these paragraphs, which explain that conclusion, explain what that means, what the fact that the Kamari test has been adopted or has been readopted, what that means. Paragraph 119, fact-sensitive exercise on a case-by-case basis. You have that submission over and over again. 120, it is not necessary to show complete reliance or absolute dependency. There is none of the cases go so far as to require exclusive or complete dependency. That's true but both by the negative, none of them require exclusive or complete dependency, and by the positive. I've taken you to Alvarado, where the Strasbourg court makes clear that that's the case. And then, importantly, we say then from 122 onwards. So real effective follows from the fact that additional elements of dependency over and above normal emotional ties is the test, that real effective and committed support is not the test. We see that in paragraph 122. On a proper analysis, it's different, rather possibly more nuanced than the summary at paragraph 10 of the judgment. Dependency may in one sense be the other side of the support coin. But why is it? So why are they different? And it's important to see why, because it explains why it may not be wrong to refer to the real effective and committed support test. So why are they different? Because real support may be provided without any serious dependency, and even effective support might be provided without there being meaningful dependency. So we just stopping there. If a court made a finding, if a court got the test wrong, because it was making this decision in 2023 or 2024, and it made a finding that was real effective and committed support, but you could see from its findings that in fact it was also either making a finding of serious dependency or meaningful dependency, or if its findings clearly led in that direction, then the error in the statement of the test, we say, would be immaterial. So that paragraph is crucial, 122, because it explains the reason why the tests are different, but it also explains the reason why misstatement of the test may not be fatal. And again, the same point is set out in the subsequent paragraph, 123. Real committed and effective support is not the test itself because the level of real support may be minor or insignificant. So, whereas the word dependency denotes a significant relationship. So if you have a finding of real effective and committed support, but also a finding of a significant relationship, then that may well solve the error or resolve the error that results from the misstatement of the test.
Well, isn't the point being made in 122 that it is different opposite sides of the coin?
So that's
dependency being looking at it from one person's position and support from the other.
Yes. So
is that what's being said?
So a submission, that was the submission that was made on behalf of INA. So IA said it doesn't matter because if there is real effective and committed support, it's just the other way of looking at dependency. And the Court of Appeal slightly hedged its bets on that, but explained, I respectfully submit, but said to a certain degree, but only if you make clear that the real effective and committed support also passes those thresholds of serious dependency or meaningful dependency. So the worry was that you can have real effective and committed support without any dependency or without meaningful dependency. And you see that again in 123. The problem is that the level of real support might be minor and significant, but dependency denotes a significant relationship. So in order to save a decision which uses the wrong test, there would have to be something else from which you could see that what was being referred to as a significant relationship or meaningful or serious dependency. That's the way in which the two. So, and it's for that reason.
Sorry, you say that's an alternative characterization.
Well, I'm making a submission of this is the way that I'm inviting my lords to read 122 and 123, and if I can then ask you to look at the paragraph 132 on page 248.
You're obviously leaving behind 125.
I'm going back to it. I just want to. Sorry, I will absolutely go back to it. Sorry. So actually, in fact, if I can take you to 128, it's just because these are still cases about the interaction between the two tests. So 128, the UT's error was where it referred to the real effective or committed. Sorry, real committed or effective support test. And why? And the Upper Tribunal said no, but it's obviously, in reality, it's applying an exacting test. And this court says, no, that's not right. Why not? Because the FTT had also found that that's less than dependency. And so the combination of real effective and committed support with no dependency can't pass the correct test. That's why the FTT's decision and the Upper Tribunal's decision had to be set aside in the IA case. And that's very different from here. There's certainly no positive finding of no dependency. And then, as we have explained, dependency is different from support. Establishing real, committed or effective support by itself may or may not be sufficient to establish additional elements of dependency. So just applying that test doesn't make a decision. It may be a legal error, but it's not necessarily material, because it may be sufficient to establish additional elements of dependency. But you're going to have to be able to work that out from the decision itself. And then 132, which is more on the same point. And this is when, so I'll take it. So this is this court returning to the same point, but now in the context of remaking, restates the test, and that says the existence of real, committed, or effective support is relevant but not conclusive. The evaluation of whether family life exists is fact sensitive, with many other factors, including financial support, physical and psychological health, and a combination of other factors. So again, if you can see from the other factors that are taken into account, that test does establish additional elements of dependency, or that the tribunal has found additional elements of dependency, then it's not going to be necessary to set aside the decision. So those are my submissions about the link between the two tests. Yes, my lord. Then going back to 125. My lords, my learned friend's taken you there, and the first point I would take from that, and I think my learned friend very fairly made the point as well, that there are no hard and fast rules. There are examples in Kamari of the kinds of physical and mental dependency which might qualify, but they're not factual precedents, because as the Court of Appeal emphasises, they are not exhaustive, and dependency may take many forms. And Lordships have already seen Kamari twice. And it's not always necessary to show exclusive dependency. Whilst one person being completely dependent on another might normally satisfy the additional elements of dependency test, it's not the only way the test can be satisfied.
Normally seems a bit surprising. You've thought of you're completely dependent.
Yes,
might be expected to satisfy.
My lords, I'd invite you to read that as if the word normally wasn't there. It's clear from all the rest of it, if you were completely dependent, you must have additional elements of dependency. And so but I agree more.
I have to say, speaking of myself, I don't find this altogether easy.
No, it's not.
If you look at the first 4 lines of paragraph 125, it suggests that it requires some dependence, and dependence is more than the existence of support, even if that support is qualified by the adjectives real, committed, or effective. But compare the last 4 lines of paragraph 128, which you showed us a moment ago, which suggests that establishing real, committed, or effective support by itself may or may not be sufficient, but at least one possibility is it may be sufficient.
Well, the answer must be, it depends how real and how effective and how committed the support is. That must be what's being said. Just reading all these, it's not very easy to read all this together, but that must be the way of trying to do so.
Or is it like, as my lord was saying, it's looking at it the other way round? I don't know, a parent may supply a child with all sorts of financial support. I'm talking about an adult child, say. But nevertheless, the child may not actually be dependent on it. So we're not so much concerned with what's being given as the reliance on.
Yes, that may be right. And financial support is a difficult example, because we accept that financial support by itself has never been held just pure financial support. Exactly, because there are plenty of people who give money to relatives without the relative being dependent. And I think in Kogarthas itself, financial support wasn't referred to as being the test, but my lord, exactly. You can imagine other examples where some kind of benefit is showered on a relative, and the relative doesn't care very much, and that's
they're getting a lot of support, but
they're not dependent on it, or they're not emotionally dependent on it. I mean, that may also be right. But it's if you read, Well, I'm not sure that I can do much better than to say that the way that I would read this is that what you need is either the real or in order for real, committed, and effective support by itself to get you home, it has to be of a certain level of seriousness or of a certain level of significance, and you must be able to infer that from the decision.
What you're looking for is dependence, is the level, is the additional element of dependence. That may or may not be established by reference to the real, committed, or effective support. But real, effective, committed, or effective support is not by itself dependence. That is what these two passages seem to be saying.
Moral, yes. So
I don't think there is a conflict between 135 and 138.
So maybe you have to turn around and just look at this through the eyes of the person who's receiving the support. And
I think
see
that is
whether you
probably
can infer from that. I think that's what my lord was saying, isn't it? So maybe that's the way. But you have to look at whether the dependency is more than trivial. It has to be meaningful. Or it has to be something additional, over and above the emotional ties that I would have towards my dad who is giving me money. There'd have to be something over and above my gratitude or my fondness for my dad. There'd have to be some way in which that was, again, finance isn't a great example, but just using it hypothetically, there's something that's been given to me which means more to me than just a part of my visiting, as Lord Justice Sedley's example in Cogarthas, family members that we like to visit and stay in touch with and we're fond of.
Would you accept that we must be careful when looking at all these cases to bear in mind the context in each case in which these words are being uttered, because family relationships are very different.
Yes.
And the dependency, for example, in the children who've just fled the nest, on the one hand, and the adult children a lot further down the line, it's quite a complex. They're different things.
My lord, yes. Well, it's not a straightforward test. I think that's why there is this repeated requirement that it be looked at on a case-by-case basis. It's not, in fact, a terribly straightforward test to apply, but the tribunals are charged with applying it. But so in that EM Lebanon, in the quote from EM Lebanon about the different forms of family life, it's clear that at different times in life, dependency is likely to take different forms. So if you're a 2-year-old child, your dependency is going to take a different form from the dependency that an unwell older parent has.
Is it a purely objective test?
My lord, I'm not sure.
That's
not
probably
sure
a cul-de-sac.
answer that question, and I'm not sure. I'm not sure it can be. It's looking. It's looking at. It must be looking through the eyes of the person who is depending, or looking from the point of view of the person who's depending. Is it not? Can I not answer that question unless you need me to, because I haven't thought about it. Whether it's an objective or it's an exercise of judgment for the. It will depend on the characteristics of both or all of the members of the potential family, on all of the circumstances, on all of the factors which are identified in the case law. I'm not sure that I can straightforwardly answer whether that's objective. So if just again to hypothesize, I wonder whether I'm risking taking ever such a long time, because it's but I probably better move on. But imagine a person who subjectively experiences complete dependency upon someone. It would be difficult to say how that would not be dependency. So if a person is emotionally dependent, subjective, so on someone else, but can I not? I'm pontificating on something I haven't thought about properly, and I'm not sure it's necessary to decide. So. Yeah, sorry, I've already done that. Yes, Lord. So that's what I have to say about the first ground before the court and IA and others. The second question was who has rights. So the Secretary of State's initial position, again, in this litigation was that a person outside the UK is not a rights holder for the purposes of it's no longer it's not pursued by the time the case comes to the courts at all. But it underlies the way in which the court approached ground 2. So the Secretary of State was suggesting that a person that even if there is a family, so even if there's an Abbas-style jurisdictional peg in the UK because a family member is outside the UK, that the family members who are outside the UK have no rights at all. And you can see from the judgment in I and others that submission was rejected. Again, it's not necessarily entirely easy to apply this, but what this court decided in I and others was that the focus should be on the rights of the person who is in the UK, but not that the person in the UK is the only person who has rights under Article 8. So if I can just take you to the passages that deal with that. The summary of the court's conclusion is on page 226, paragraph 11. So the court is looking primarily at the Article 8 rights of those persons within the jurisdiction of Article 1 of the ECHR. Quite what that, again, it's possible that later on in the judgment that's placed slightly more, that's given slightly more nuance. It's a little bit difficult to read. But what the court is not saying there is that a person who is outside the UK has no Article 8 rights. So it's not saying it's looking only at the rights of the person within the UK, and it's not saying that the person outside the UK has no rights. So we're not in Al-Skaney territory. We're not in the territory of trying to find an extension of jurisdiction, an extension of Article 1 outside the territory of the UK. In this kind of Article 8 case, where there is family life established with a person who's in the UK, then the whole of the family enjoys an Article 8 right, and the jurisdictional peg arises from the fact that one family member is in the UK.
So when deciding whether the interference with the right is proportionate,
yes,
which is what we're dealing with, is it not?
Yes.
Proportionality. Whose rights are we looking at?
Well, you're looking... Again, there is no bright line rule here. And so the Court of Appeal could have said you're only looking at the rights of the person in the UK. The person outside the UK has no protected rights. And it doesn't say that. It says the position is more nuanced than that. You're looking primarily at the rights of a person in the UK. Now, the difficulty, which I respectfully submit, arises from that is when everything is a matter of weight, it's quite difficult to see how there's a rule that you look primarily at one thing or another, rather when there's nothing bright line. But clearly, I can't say clearly. What I would invite, the way I'd invite your lordships to read this is that you look primarily through the eyes of the person who's in the UK when you're looking at the severity of the interference which needs to be justified. That must be the way in which this question has been being resolved. It would have been easier, although wrong, if the Court of Appeal had simply said someone outside the UK has no Article 8 rights and all you can look at are the rights of the person in the UK. That's plainly not what they concluded.
As you say, it's not. In some ways, you could sort of justify either extreme more easily than the middle position.
Exactly. and so having decided that everyone has a right, it's difficult to establish a kind of rule about weight rather than a rule about
Yes.
The other thing, I don't want to set hairs running because, as you say, we probably don't need to, in this case, explore this at length. But the other thing is that I think English lawyers tend to use the word jurisdiction in a slightly different sense from the way it's been understood in Strasbourg. I think one has to, because I just look at the last two lines of paragraph 11.
Yes.
Within the jurisdiction, very much has the flavour of within the territory.
Yes.
In our civil procedure, we often talk about allowing someone to serve a claim outside the jurisdiction. So
Well,
That's not actually what Article 1 says.
no.
You can exercise jurisdiction. It's very common outside the territory. And a commonplace example is the courts do it all the time.
And that's
Well, when we make a freezing order over assets on a worldwide basis, we're exercising jurisdiction,
yes.
although outside the territory of the UK. That would, seems to me, fall within Article 1.
Yeah.
So one has to be slightly careful. I don't think it matters in this case, because you
I
say...
think we all agree that what is meant here is outside the UK. Really.
Yeah, and that it's not an exclusive test. What they're saying is looking primarily.
Yeah.
Fine.
My lord, yes, it's also difficult to imagine how someone who's actually outside Article 1 has any rights at all, which are protected. But that may be but maybe I'm wrong about that.
Well, as you say, you've got a lot of other things.
We've got a lot of things to worry about. So, my lords, I think that's probably all that I need to say about the second round. Just that the way in which it's dealt with is nuanced, and we can see that in the result. And I'll take your lordships to that, because when this court goes on to decide proportionality for itself, it does have regard to the circumstance of people who are outside the UK. It's very clear that it does that. It doesn't ultimately find the decision to be disproportionate. It certainly doesn't exclude the rights of people outside the UK, and I think my learned friend will accept that. So the third question which it dealt with is the question of proportionality. And you've been taken to some of the concern. I'm taking you back where you've already been, page 252, starting at paragraph 151. Of course, all of this is academic, you see, but the kinds of questions which are considered are 5 lines down in 151. The circumstance, so looking at the weight to be attached to family life. So we're assuming that family life has been found. The circumstance in which it come into existence, well, we say in the circumstances in our case are a core family. The type of family life that was concerned, the length of time it existed, and its likely future development. And that's important. The likely future development of family life is relevant to the amount of weight to be attached to family life. Provided the family life exists in the first place, provided you've got over the hurdle of having family life, then the prospects of intensification of family life are relevant to the proportionality exercise. And then my learned friend relies on the passage, or the phrase a few lines further down. It was also relevant that the relationship had been rekindled in the knowledge that the family had no right to enter the UK. And our starting submission here is that it's very different. There is a very significant factual difference at the very least between the rekindling of this relationship after 18 years when the family members had not seen each other and not seen each other face to face at all, and the circumstances in which in my case today, in our case today, the relationship was rekindled as soon as the appellant and his parents and family got back into contact. So the relationship gets broken down for 2.5 years. And I'll come back to it when we look at the First-tier Tribunal's decision. But very different circumstances. And I think my learned friend tried to draw a direct factual analogy between the rekindling of the relationship in I and others and the getting back in touch by the very young, vulnerable person who's fled Afghanistan with his parents who've also fled Afghanistan. We say there's no comparison at all between those two factual scenarios. 157, you've been taken there again, that best interests, they can't be a trump card, and the Court of Appeal thought that the Upper Tribunal had treated them as such in IA and others. But there's no dispute, and my learned friend accepts that the best interests of children outside the UK are relevant in the normal Article 8 way. The 158 from Agyarko, requirement for exceptional circumstances. My lords, I'm sorry that I don't have the case before you, but Agyarko is the source of Lord Reed's explanation of what exceptional circumstances are, and he talks about unjustifiably harsh consequences. So exceptional circumstances is a formulation of a proportionality test, but which has regard, which pays high regard to the Secretary of State's policy decisions about immigration control. Then you've been taken to what's said there about policies and the Secretary of State's role in deciding who should be admitted to the UK and not. And then at the bottom of 160, and my learned friend took you to this, had there been one, the policies of the Secretary of State might have favoured the family and allowed the balance to be struck differently. And it was an important part of the case in I and others that there wasn't a policy that was of relevance. In 166 to 167 over page 25, on page 255, the Court of Appeal in that case formed the view when it read the Upper Tribunal's decision that the Upper Tribunal had not placed sufficient weight on the Secretary of State's policy. But that must be a matter, that's not establishing a precedent, it's an observation about the decision in that particular case, we say. And then, so we're in the remaking section of the proportionality decision on page 256, and it's important to see what the Court of Appeal would have taken into account if it had found that there was family life. So it's a doubly overturn. But it's doubly academic, I should say. Sorry, doubly academic. But the would have attached some, but not great weight to the past and future family life. So the past family life.
Sorry, where are you?
Sorry, my lord. Page 256, paragraph 172.
Yes, I see.
Would have attached some, but not great weight to the family life that had been in existence since the end of 2023. Had never involved cohabitation and had been recently revived and contingent. We would have attached weight to the interests of the family in wanting to leave Gaza and to abate the risks in the humanitarian. So that's the answer to my Lord Justice Singh's question about the person stranded in Nazi Germany. There's no suggestion by the Court of Appeal that a decision maker about proportionality in an entry clearance case has to shut its eyes to Article 3 issues. I completely accept, of course, that you can't introduce Article 3 through the back door, but introducing Article 3 through the back door means a person who has no family life in the UK, has no jurisdictional peg in the UK, saying I must be allowed to come into the UK because I'm at risk of Article 3 ill treatment out of the country. That's not what. But once you've got the family life, then the fact that you face risks of serious harm in the country where you are is relevant. It has to be, the focus has to be on the impact on the sponsor, maybe, but it's not very difficult to see how there could be an impact on the sponsor in certain cases. But there's certainly no hardline rule suggesting that Article 8 considerations, or they're not Article 8 considerations, because it's not within the Convention, but risks of serious harm, just using that term non-legally, that risks of serious harm outside the UK are somehow legally irrelevant. That's not what the Court of Appeal does or says. Also in 172, we attach weight but not paramount weight, so primary consideration, not paramount consideration, is the best interest of those children of the family, and we would have attached some weight to the difficulties faced by the brother in Gaza. He was anti-Hamas, he is anti-Hamas, and the risks to his safety and humanitarian position there. All of the factors. So we are in absolutely standard Article 8 territory. You look at everything that's relevant. There aren't any hardline rules excluding. It's very important because my learned friend, some of his submissions make it look as if there are factors which are simply excluded, and it's not the case. And then we have attached some, but not great weight, to the anxiety and PTSD of the sponsor, and the plans he'd made to accommodate the family. And again, I've made the submission that we're not in factual precedent territory, but it is striking that the sponsor in the IA case was earning £4,000 a month still and fully functioning in UK society. It's not difficult to see how that contrasts with the position of, very sadly, with the position of the sponsor here. And then finally, at 173, and you've seen this again, had there been a policy, bottom of 173, part 276, the balance might have been very different. So that's the background against which the ECO says that the three decisions of the Upper Tribunal are unsustainable or unlawful. Can I take three grounds in turn now? You've already heard some submissions about this really in the course of what I've said, so I'll try and speed through it a bit, but I do need to, if I may, take you back into those decisions. So the first ground, was the Upper Tribunal entitled to set aside the First-tier Tribunal's decision? Turns on the question of what is meant by normal emotional ties. And I've already said that's a question which arises in all contexts, not just immigration context. And the question whether family life established is a logically prior question. I'm using a term actually that my Lord Justice Singh used, I don't know, in a case of Onawara. It was a case about visit visas, where one of the submissions that was made was that the question whether family life had been established depended on the type of application which was being made. And it was submitted that if I was only wanting to come for a visit visa, I could rely on a lower threshold of family life. And this court rejected that submission. But one of the, in part on the basis that the question of whether family life was established is logically prior to the question of whether there's an interference or whether the interference would be disproportionate. And we say that if a decision maker misunderstands, so the context, immigration or adoption or deportation, entry clearance, is not relevant, it comes afterwards. It may be relevant at the proportionality stage. It doesn't affect the test of family life. We say that if a decision maker misunderstands what normal emotional ties mean, then she or he is likely to fall into error, or there's a real risk that they will fall into error when they decide whether there are additional elements of dependency over and above them. So if the test is additional elements of dependency over and above normal emotional ties, or real effective and committed support over and above normal emotional ties, which is what the First-tier Tribunal thought in this case, it matters not. When you're looking at what is over and above normal emotional ties, you have to know what normal emotional ties are. And as I said at the start, our submission is that the First-tier Tribunal required the respondents to show not elements of dependency over and above normal emotional ties, but elements of dependency over and above abnormal or already elevated emotional ties. And therefore it set the bar too high. That's the error it made. It's the error that the Upper Tribunal identified. And I'll come back to it, but we adopt the Upper Tribunal's analysis. But for the clarification of the test in I and others, but we adopt the Upper Tribunal's analysis at pages 78 to 79 of the core bundle, paragraphs 69 to 71. So just looking at the First-tier Tribunal's decision, so that's in, and I'll take you back there, that's in the core bundle 97 to 115. We accept, as the Upper Tribunal did, we obviously accept that the decision is careful, contains a detailed assessment of the evidence which was before the First-tier Tribunal, and we also accept that the First-tier Tribunal's decision has to be read fairly and as a whole. We also accept that the question whether the First-tier Tribunal erred is an objective question. Sure of the answer of that, which this court is in as good a position as the Upper Tribunal was to decide. So to a certain degree, I can adopt the bit of the Upper Tribunal's analysis. It doesn't really matter whether I do or not. It's for the Secretary of State in this case to establish that the First-tier Tribunal error didn't contain material errors of law. Can I just invite you to look at some of the findings made in the First-tier Tribunal? So if I could ask you to turn up with some of the evidence heard, and all of it, of course, with one small exception, all of the evidence was accepted. Page 103, paragraph 45. And this is, and of course I have the point that my Lord Justice Baker made about us not island hopping through this relationship and picking out odd moments. But this is the first time that the family members see each other again after the separation, and this is the summary of the evidence of Mr. Perkins. So his evidence is found to be very impressive. So he's saying he notices all the family members are overjoyed. It's an emotional experience from which the sponsor became much lighter and his headaches reduced markedly. So there's an improvement in his physical health when he sees his family after this length of time. There's potential for enjoyment and relaxation. So not just relief and not just enjoying seeing his family, but potential for relaxation. And then when he returns, his mood plunges into depression. He becomes more introverted, struggles with sleeplessness, and a deterioration in his mental state. Mutual concern and joy. So that's the first piece of, that's one piece of evidence. 48 on the same page. So the sponsor ends his therapy in 2023, but his therapist is concerned that the sponsor's come to the end of he's in the same position as when they started. He can't move on because of his worries about his parents. His separation from his family undermines this, and that without family support, it would be almost impossible for the sponsor to do the work that is required to build up his life by continuing his studies, training for employment, and developing a social life. And just flashing back to the Huang description, comes a point at which people won't be able to live full and fulfilling lives. Well, that's evidence of that. It's accepted evidence that the sponsor is being prevented from leading a full and fulfilling life because of the separation from his family. He's quite isolated. He has one friend he's known from childhood. Quite a lot of weight is put on that by the First-tier Tribunal. It has to be put in context. All aspects of the sponsor's life are areas where there are significant challenges. When considering whether the sponsor has achieved the appropriate level of development for a young adult in terms of employment, social circle of friends, relationships, having the family here would give the sponsor a platform which would help him grow, partly through their presence, but also because he will have to perform the tasks they want performed. So he will receive and he will give if his family members are here. And again, measure this against full and fulfilling lives, and whether the permanent and unavoidable separation from his family members are preventing him from that. We say this is evidence which clearly goes to that. And then 50 on the top of page 105, the sponsor functions in some respects like a person in mid to late teens. So he is retarded in his personal development. He's functioning like a teenager, although he's in his mid-20s. That's some of the evidence that was before the tribunal. And then turning on to page 108, paragraph 65. And my learned friend's taken you to this reference to he's young for his age. Paragraph 65, reuniting the family would have beneficial consequences, but not just beneficial consequences for the sponsor because he'd be happy. Beneficial consequences for the sponsor's recovery. So infer from that the sponsor's recovery.
Sorry, I've lost you again.
Sorry, my lord, it's at the bottom of paragraph 66 on page 5.
Oh, I see. Yes. Yep.
So recovery is important. It's not just that it'll be nice for him; it's that it will be beneficial to his recovery. And we're in the reasons for decision section, and we now get on to where, in our respectful submission, the FTT starts to go wrong. And my learned friend said there were 5 elements to it, or 5 sort of sections of its finding that there were not elements over and above normal emotional ties. And I don't disagree with that. There are different sections. There are different things considered here. But just going through this section. Firstly, paragraph 70. So this is an extract from Kogarthis, which isn't disapproved. But what does Lord Justice Sedley think is meant by normal emotional ties? He talks about close relations of whom we are extremely fond and whom we visit or who visit us from time to time. None of us would think that we have family life in the meaning of Article 8. And that's normal emotional ties. And Sir Stanley Burnton, love and affection between adult and his parents and siblings. That's a normal emotional tie. The question, therefore, is whether there are, in 72, whether there are probably stronger ties. And then we have the reference to the wrong test. But what the First-tier Tribunal is trying to do here, and what we say it does wrong, or does wrongly, doesn't depend on whether that test is correct or not. Because what the Tribunal is doing here, definitely, is saying, is there something over and above normal emotional ties, including that there isn't. And so, at the bottom of 72, the Tribunal starts to go wrong. It says
do you accept that in the first part of paragraph 72, the Tribunal is still going right?
Yes, I mean, until the word because. Sorry, so it's because they, and it may well be that so certainly until the word because in the 4th line of 72, and even after the word because, for the same reasons that I've said before, the Tribunal could still reach a conclusion that was correct, depending on what else it did. And I've already explained why we say that referring to that test isn't faithful.
It seems as if your complaint starts to begin with the final sentence of 72.
That's right. So we're not disputing the correct misdirection, in the sense that the Tribunal misdirected itself correctly in accordance with the law as it was understood at that time. That's what happens in the first. Sorry, that sounds flippant. I don't mean that. But so I accept that the first 4 lines of 72 reflect the law as it was at the time. And so yes, we submit that things start going wrong at the end there. And firstly, because what it's doing is it seems to be saying that normal emotional ties go up and down. And if I'm going through a prolonged period of severe illness, then I'm going to have to show more. Or if my family member is going through a severe period of a prolonged period of severe illness. So I'm looking after my mum. She's going through a prolonged period of severe illness. That's already factored into normal emotional ties. I'm going to have to show something else over and above that.
Strictly, I'm not sure that grammatically that's what he's saying. He's talking about the manifesting themselves in those circumstances.
So it's the word such. It may be, my lord, it may be that I'm. This is where we say that the Tribunal is starting to go wrong. It may be that's right. Well, I've read such as meaning such emotional ties. What you're looking at is emotional ties which will go up and down with the circumstances.
Or is he rather saying you find out whether there are these emotional ties by looking to see what happens in these circumstances? That's
my lord, it may be, but if that's true, then we say that's not what the Tribunal then goes on to do. It'd be difficult. I would accept that if you look at someone who, in their family life, finds themselves looking after a family member, an aunt or a mum or a parent or whoever, who has a prolonged period of serious illness, and as a result of that, emotional ties increase or dependency increases, then that would you can look at that increase. But what you can't treat that as a moving base. I'm not making myself very clear. What it would be wrong to do would be to look at a moving baseline, so that the worse my conditions, the more I have to show over and above, and the more I have to show over and above the baseline. So the more my mum gets ill, the more she becomes dependent on me, the more that's just treated as being normal. It's normal for me to
I must say, I don't get that from this sentence. He says, the extent to which such emotional ties manifest themselves. So you've got to, on this hypothesis, you seemingly have emotional ties. They're not varying. It's just that you can see them having an effect.
Oh, I see. Well, if that's what's being said, then that probably isn't going wrong.
It's quite difficult for my part trying to see how this should be interpreted if we apply the right test and not the wrong test. It's a difficult exercise.
So yes, it's slightly difficult exercise. I'll move on from that then, because that's not where I'm saying that's where things start to go wrong. And maybe they
start to go wrong on their own terms.
On their own terms,
right.
Yes. Whatever tests we're applying, but where they then go more wrong, we say, is in paragraph 74. So there's a finding 73 in line with the authorities that you've seen, that while sponsor is living with his family, his siblings and his parents in Afghanistan, there is family life. He turns 18. Family life isn't extinguished by him turning 18. That's 73. He's not formed an independent life. But I'm satisfied this probably changed when he left Afghanistan. Then there's this section. I wasn't referred to in any evidence. So he flees Afghanistan. He flees his family village because the Taliban want to recruit him. He flees Kabul because he's stabbed, and he comes to the UK in circumstances which are set out. And you'll have his evidence about that is in the First-tier Tribunal, the old First-tier Tribunal determinations appeal, which is in the supplementary file. I'm not going to take you to that. He only speaks to his father once during his journey and then loses contact with his family completely. The inevitable inference, says the First-tier Tribunal, is that he must have realised that his life with his family was over and he would have to make a new life for himself on his own. And with respect, that's just nonsense. There's no inevitability about that inference. The fact that someone who has been forced to flee a country loses touch with his family for 2.5 years doesn't leave inevitably to an inference that the family life is broken.
Can I just fit this in? On the face of it, this is a finding of fact, I suppose.
Well, it's a finding that there is an inevitable inference. Can I just take you...
Well, just pausing on that sentence, you say it's nonsense. There's
Sorry,
a
I shouldn't
finding
use
of
the word
fact,
nonsense.
possibly, that he realised that his life with his family was over and he'd have to make a new life for himself on his own. Now, that isn't the basis of... Any attack on that isn't the basis of the Upper Tribunal setting aside of the decision, is it?
My lord, no, it's not, but it's the backdrop to what goes on. Can I just refer you to some of the evidence about that? You're absolutely right. That's not the basis on which the Upper Tribunal set aside the decision. But it is relevant to the question whether the First-tier Tribunal is starting to go wrong, which is a submission we're making in response to the Secretary of State's grounds of appeal.
Just diverting you a moment longer. I mean, the point here is the Tribunal decides that there had been family life, but it had probably gone. Is that an issue?
Well, yes, it is.
Was that? Does that feature in the Tribunal decision?
It doesn't feature in the Tribunal's decision because it didn't need to. But since I'm taking it, can I just refer you to so there was very clear evidence before the Tribunal that's wrong. It's in the supplementary bundle at page 211, paragraphs 12 to 14. My lord, I absolutely accept that's not the basis upon which the Tribunal set aside the decision. But you have the...
What page, sorry?
So it's 211 of the supplementary bundle. So, bottom of paragraph 12, having to leave the country and leaving my family very far behind came as a shock. I never expected it to be so long without them. And then paragraph 13, I don't know when exactly my family left Afghanistan, but I had some hope they would get to me. After I left Afghanistan, it got difficult for us to communicate. The last time I was in contact was when I was in the jungle. Then I lost contact. That's when they were travelling and having to hide in Turkey and didn't know who they could trust. So there was evidence that the appellant was expecting to, one hoping at the very least, to see them again. I accept there's no evidence of a firm plan. In any event, the question is, so that's the question 75. I accept that the question is whether family life still exists now. To that extent, it's not crucial whether family life did or didn't cease to exist between 2016 and 2019.
There's only no dependency in that period.
Well, there's no active dependency, but then again, that goes back to the question that my Lord Justice Singh asked. If you flee a country, and you are hoping for renewal, you may still be emotionally dependent on the hope that you'll be reunited with your family, and that's what we say. That's what the evidence is, and we say it would be surprising if family life would be judged to have ceased because you weren't receiving practical support during that period.
Quite a few of the way in which you've been expressing it, understandably, and it's in the authorities too, in the situation where there has been family life, yes. And has it been lost, is the way you've been sort of characterising it at times. Is that the way to look at it? When if we're looking at additional elements of dependency, to what extent is it helpful or right to look at, ask, has this family life been lost?
My Lord, I agree that the focus had to be on whether there is family life now, but that can be informed by. So the reason why the reason why this is relevant is that my learned friend keeps relying on the factual observation made in I and others that family life has been rekindled recently, and it's for that reason that I thought it was necessary to take you to evidence that family life was never abandoned, as my learned friend the First-tier Tribunal makes the finding that family life must have been given up on. The response must have given up on family life. That's not what the evidence is. I accept that it's probably peripheral to the actual question which the First-tier Tribunal had to decide, which is the family life now.
Yes.
And I accept that questions about the sort of archaeology of that family life aren't necessarily the crucial ones, but they can inform certainly the weight that's attached to that family life.
Once you start to bring emotional ties into the equation, that really confuses it, doesn't it? In a sense, because obviously we all have emotional ties to people with whom we were in a close family relationship, but they may no longer be a dependence.
Yes, there has to be an emotional dependency. Applying the test as it's now, as another reason why the test isn't very easy and necessary to apply. But I accept that if you had a situation, again, this is possibly quite hypothetical because I accept that the tribunal was not required to decide, and that's why it wasn't required to decide was the family life in 2017 and 2018. That wasn't going to be determinative of the question before it. But if it were deciding that, and it was presented with evidence that because the sponsor was living in hope that the family from whom he'd been separated in very traumatic circumstances 18 months ago would eventually find their way to him, then that one could perhaps quite easily infer emotional dependency from that.
I see the logic of this. I also see that we're dealing with something that probably is at best peripheral,
yes,
or at most peripheral.
Shall I move on?
But
sorry, yes. But it
isn't the basis of the Upper Tribunal's setting aside decision, and I think it's right that the Upper Tribunal never comes back to this in its later decision, does it? So we've got, on the face of it, a finding of fact which has never been set aside and has never been revisited. Or is that an unfair characterisation?
My Lord, it may not be unfair, but I am, as I say, I'm responding to my learned friend's repeated references to the rekindling of a relationship, and in those circumstances, this, from having been a peripheral issue which wouldn't have been at the forefront of anyone's mind when the Upper Tribunal was looking at family life now, it does come into proportionality balancing exercise. I'm not putting any higher than that, but it would be maybe I should just nothing. It wouldn't be appropriate for a significant factual analogy to be drawn between the rekindling of family ties in I and others and the rekindling here, where that wasn't the focus of the attention in the Upper Tribunal, where on the face of it, the First-tier Tribunal overlooked evidence. I absolutely accept that wasn't a direct basis of challenge to the First-tier Tribunal, but does become relevant if the Secretary of State is taking the point now. Yeah. What the paragraph 75, the sponsor has not yet formed a relationship or developed a full social life because of mental health problems, but of course those mental health problems, as I've taken you to the passage already, are the result of, or the failure to, his inability to recover from those mental health problems is the result of his separation from his family. I've taken you to the passage there, that's paragraph 75. I do not accept there's any form of financial dependency. Might be slightly an overstatement, but it doesn't matter. So we don't struggle with that paragraph. But paragraph 77, again, seems to be imposing too high a threshold. So as there's no financial dependency, there are practical limitations on what the appellants can do to support the sponsor. And there's a series of things that the appellants don't do to support the sponsor. And it very much focused on, I took your lordships to EM Lebanon, where Lord Bingham said, well, no doubt the mum in EM Lebanon provides the kinds of services that a mum normally does for her child, but that's not what family life's about. And there's very much a focus here as if what you need to show over and above normal emotional ties is some sort of practical support rather than some additional emotional dependency. So that's the difficulty with 77. And then in 78, and through to 80 is where the tribunal makes the errors that the Upper Tribunal, the First-tier Tribunal makes the errors that the Upper Tribunal found. So this is where the tribunal is looking at, the First-tier Tribunal is looking at whether there is emotional support, and read that up as emotional dependency. And this is where I say that the tribunal is doing what I thought it might be doing in paragraph 72, because this is where it is saying emotional ties may fluctuate, and so, for example, where there is an illness, presumably a lengthy, serious illness, then emotional ties may increase. I don't accept this is anything more than a manifestation of the ordinary emotional ties. And what the Upper Tribunal says, well, the kinds of emotional ties which are manifested by phone calls over and over again because a person is seriously ill and you're trying to help them or look after them, isn't a manifestation of normal emotional ties. It's a manifestation of abnormal ties in abnormal circumstances. And what the FTT did, what the First-tier Tribunal did, was it erred in looking for something over and above what was already an indication, at least in principle, of something over and above normal emotional ties. And then at paragraph 80, the tribunal goes further, and we respectfully submit further into error, because he accepts that the visit to Turkey was highly emotional, but he says any close relatives who were reunited in similar circumstances would be overjoyed, irrespective of whether family life exists, and that's back to front. What needed to be looked at here was what would close relatives who were normally saw each other after 2.5 years do? What would their emotional ties be, or what would be the consequences of seeing each other after 2.5 years? And then look at whether the consequences of this particular meeting were evidence of more than the usual emotional ties. And again, the consequences were that the appellant became mentally less unwell, stopped having headaches, was able to relax. We've seen that from the evidence. But the error is to treat the similar circumstances as the normal condition against which normal emotional ties would be measured. You don't look at, if you're judging what's normal, you don't look at the kinds of emotional ties which would exist between family members who had been separated in the way and had lived through the experiences that this family had done.
Can we just look at paragraph 80?
Yeah.
So we're trying to work out whether there are more than normal ties. So suppose, for the sake of argument, there were simply normal ties, and then after a long period, there's a reunion, and everyone's overjoyed. The fact that everyone was overjoyed wouldn't evidence more than normal ties, would it?
No, but the evidence isn't that everyone was just overjoyed. The evidence is that the sponsor was temporarily cured of physical and mental illness.
And I see that there's that evidence, but that's not what the judge is talking about here. He says, I accept it was a highly emotional event, but I don't accept that the joy establishes anything particular. So the question is, has he gone wrong in saying that the joy doesn't prove more than normal ties? Well, has he?
So what he's saying is, I'm looking at what happens when close relatives are reunited in similar circumstances.
It doesn't stop at 80. 80 and 81 go together, don't they? You can't look at the joy point on its own.
Yes, no, that's right. So, but I'm sorry, I'm trying to work this.
You're responding to what I said.
I am, but that's absolutely right. So there are two things, aren't there? One is just calling this nothing more than joy, and the second thing is looking at the emotional ties between, or evidence of what people do if they're in similar circumstances, and what see from paragraph 81, but then also from the evidence I took you before, is that over and above the consequences of that first meeting, there's the accepted evidence of the social worker of the impact it has on the sponsor's mood and presentation when he is in face-to-face contact with his family members.
I mean, I suppose there are two questions. Well, maybe there's one question. I've spoken.
Go on. So there are two ways of looking at this. Firstly, if I'm reading this correctly, then what the First-tier Tribunal is doing there is raising the threshold of what a normal emotional tie is and looking for something over and above that, and it keeps on raising it. The more emotionally tied family members get towards each other, the more they have to show over and above it. But if I'm wrong about that, then we fall back on the first-tier argument, because if I'm wrong about that, and the judge is saying I am looking at normal emotional. I'm looking at the kinds of ties that anyone would have with their brother or their adult brother or their adult aunt or someone after 2.5 years. Then it's perverse to characterise this as nothing more than the joy and the relaxation and the improvement in the headache and as being nothing more than, or as not being evidence of more than.
And you're quite right. There are two distinct questions, aren't there?
Yes.
As to the first, I must say it's not at the moment obvious to me that the judge is saying more than that. Looking at these manifestations, they don't show more than the underlying ties. He's not taking some abnormal level of tie and looking for something beyond that. He's simply saying these manifestations, the joy, doesn't show more than normal ties.
Yeah. So if that's what he's doing, then I rely on our second ground,
Yes,
or the
reverse.
second ground on which the Upper Tribunal. So it's not our ground, is it? But the second ground on which the Upper Tribunal set aside the First-tier Tribunal's judgment, which is that then is perverse. So either either the tribunal is doing, and my lord, I'd certainly read this in the way that the Upper Tribunal had, but if I'm and therefore had relied on what's said in the by the Upper Tribunal in paragraph 70 on page 79. I don't need to take you there; you've already been taken there. But that's the Upper Tribunal's observation about whether men in their mid-20s ordinarily spend hours a week talking to their sisters and messaging their parents. Whether what is reunification in similar circumstances, families separated by war, forced migration, trauma, years, and so on. It's the 1930s example again, or analogy again. So that's how I'd read it. But if I'm wrong about that, then what we say is this is not just happy people seeing each other after a while. This is a sponsor whose mental health, who is being given a glimpse of recovery from mental ill health and a glimpse of the future in which he can lead a full and fulfilling life. And that is evidence of, and we don't have to show more than that. We don't have to show that, but it was perverse to find that wasn't evidence of more than the normal emotional ties. Well, I think that's all I want to encounter, unless I can help further on this ground. I'll just check. I suppose I'd better go through to the end, otherwise I won't. What Mullen and Friends says that's a couple of sentences picked out of context, but they really are the crucial sentences, because this is a case where emotional ties are going to be the crucial. Emotional dependency is going to be the crucial dependency. Financial dependency is limited because the sponsor is unable to work, and the appellants, the three sisters have all worked in Turkey, and there's financial strain between them in this family, but there's not financial dependence. No one's challenging the First-tier Tribunal's conclusion about financial dependency. There aren't tasks being performed for each other by the family because of where they are and because of financial circumstances. So to that degree, 77 is right. So this is going to be a case where a proper assessment of emotional dependency is going to be absolutely crucial, and that's why the paragraphs 79, 80, 81 aren't picking one sentence out of the determination and subjecting it to excessive scrutiny. This is the core of this determination. And even then, at 83, the contact helps raise their spirits and they feel whole when they are together. Now, if the evidence is that this family who've been through trauma in this way feel whole when they are together, then on the face of it, that's evidence that they are finding a route to full and fulfilling lives when they're together. And therefore, it's evidence of more than normal emotional ties, paragraph 83. And again, finding that there isn't something over and above normal emotional ties in those circumstances, either the result of setting the threshold too high or it's perverse. In 84, again, all of these are manifestations of the ordinary emotional ties that exist between close relatives. Again, either the threshold's being set too high or that conclusion's perverse. 85, concern, but that doesn't touch on the evidence. It doesn't restore what's already gone wrong.
What about the last sentence of 85? The judge recognises that the sponsor's concerns may well exacerbate his mental health problems, but says they do not give rise to family life unless they are accompanied by the required level of support.
Well, that's what my lord. I don't know what test so what the again it's looking at it. It's looking for the circumstances back to front. It's saying, well, I am. It's using the term concerns, which is very euphemistic. I respectfully submit, given what the evidence that we have, but the response's separation from his family and anxiety resulting from that separation may well exacerbate, that would be a less euphemistic formulation, may well exacerbate his mental health problems. But it doesn't just exacerbate them, it prevents him from recovering from them, it prevents him from doing anything, prevents him from having a private life, from being able to work, from being able to be employed. But they do not give rise to family life unless they're accompanied by the required level of support. Well, in a way, this is if anything, that's a circumstance in which the wrong test disfavoured this sponsor, because what the FTT is looking for there is some kind of positive act of support, which the parents or his sisters are able to give him to try and get him over this, instead of looking at whether they're dependent on him, whether he's dependent on them. And so we say that evidence that he gets ill when he's away from them and his anxiety and is anxious about them is evidence that he's dependent upon them. It doesn't need some additional act of doing something with someone.
So in what sense is he dependent on them?
So he's dependent on them now, for the reason set out in 81, because when he is seeing them face to face, he's relaxing.
They raise his spirits.
They raise his spirit. They provide him with some kind of respite from his inability to function in the world. He has no social existence in the UK. He has no family outside this family. He has one friend here. They provide him with a respite which gives him joy and gives him some support. And then he's dependent on them because he's dependent on the hope that they'll be reunited with him, dependent on the prospect of being face to face and being able to rebuild his life. And all of those are relevant considerations in deciding whether he is dependent upon them, whether there are elements of dependency over and above normal emotional ties.
He's dependent on the hope of being reunited with them, did you say?
So he's depending on the hope of he's dependent on what they represent to him, and he's dependent on the contact that he has with them. So he's dependent upon the prospects of visits to them, he's dependent on the prospects of being with them, and he's dependent on the contact he has with them. Are those elements of dependency, which are the test over and above normal emotional ties? Well, there's certainly something over and above normal emotional ties, and are there elements of dependency to what is over and above the normal emotional ties? We say yes, and it would be. I was going to, because I think I'm coming to the end of the submissional ground one, I was going to address you on the decision you should make. I wonder whether it would be appropriate for me to do that now, because I was going to take you to evidence about dependency, and whether I should just do that now and make my submissions about what you should do if you were making this finding of yourself now, just because it's a convenient time for me to refer you to some other elements of evidence about dependency, and it may be that helps me to answer my Lord's question. Is that a useful thing to do now?
Yeah.
So, the evidence of... Can I take you to pages then 85 and 86 of the core bundle? So this is paragraph 18. This is a summary of the evidence which was before the Upper Tribunal. The sponsor has realised 3 lines down that there is nothing more that his his professional support network can do for him. And Mr. Perkins concurs. He's become stuck. He is unable to get past his constant anxiety about his family and the objective reality that they're collectively facing significant problems. The worry has increased to the point where he doesn't want to leave his home. And then the depths of his mental ill health. And then the evidence of Mr. Perkins in paragraph 6 there. He's unable to maintain a present focus. He's become lost in the past. There's a dissociation and so on. Incapable, lacking agency or function. Constance worries about his family will continue to require intervention, care and support. And then 19, the causes of his mental distress. Are complex. Blames himself for everything that's happened to his family, and then in the middle of that paragraph, without S being reunited with his family, his prognosis is poor. He will, absent that support, be unable to develop as an adult and live a meaningful life as a productive member of society. He is constantly re-triggered by his worry for his family, and his PTSD symptoms reset where they were before. So that's evidence of his dependence upon the prospect of reunification with his family and on his ongoing contact with them and hope for them in order to be able to function. And so dependency has to be read broadly enough to not to mean that you have to be able to show that you are receiving something at this moment. It must include hope of reunion. I'm dependent upon. I'm emotionally dependent upon them, whether they're here.
Isn't that circular? Because the first thing you have to establish is that there is currently family life, whereas what you're talking about sounds as if it's the hope of having family.
No, my lord, it's not at all. It's the hope of having contact with your family. It's the hope of having them in the room with you.
Sorry?
It's the hope of having them in the room with you. So it's the prospect. So again, I'm just giving the example of a family which is separated through no choice of their own and is prevented from reuniting. In those circumstances, could never be a family. If dependency were read down as meaning that, then I could never have family life with someone with whom I didn't have face-to-face contact. But the evidence is that the appellant is receiving. So I'll try and go through this as well. My learned friend has asked me to come to an end, and he's absolutely right to do so, because he needs time to reply. But there is evidence throughout both the two determinations and through the witness statements and in the annex to the First-tier Tribunal's decision of the benefit which the sponsor gets from his regular calls with the family. And so the fact that when he is on the phone to the family, everyone lightens up, he gets respite, is an element of that dependency. So if you're not with me on hope as the expectation of face-to-face contact as a part of relevant, then I would rely upon the importance, the crucial importance to him, preventing him from getting still worse of having face-to-face contact with these close family members, with his only family. And so that's what we say is dependency. Can I also refer you, I may just have to give you some paragraph references, to be fair, my friend. So, paragraph 95, sorry, page 95. These are quotes from Mr. Perkins.
Paragraph 45.
Yes, paragraph 45, and the 3 quotes there. Continued separation from his family deprives him of a potential source of emotional and relational support that would help him to contract. Being with his family would address his ongoing feelings of dislocation, and together with them he can begin to develop a new sense of home, safety, security, and of a future that can be released from the grip of his past. Now, does he not have family life until they're there doing that for him? And my submission is that can't be correct. He has the family life which is produced by the personal history, by the ongoing contact with his family, by the visits that he has whenever he can, by the impact, the dependence he has on that level of contact. And a further light is shed on that family life by the consequences, by what he is losing because he's not because he's not with his family. And again, what's the test? The Huang test is he being prevented from having a full and fulfilling life by separation from the family?
You've said that many times, and I didn't interrupt because there's a lot you've had to cover. But Huang wasn't the issue in Huang.
No. But the issue in Huang is what is family life? What is the core right? The issue that
I'm not sure it was. The issue in Huang was actually about interference and justification for interference.
My Lord, I will look it up. My recollection is that paragraph starts with, or follows on from Lord Justice Bingham saying it's important to focus on the core element, which
I know. Obviously, one pays great respect to what Lord Bingham says, but the issue of the existence of family life was not, I think, an issue in Huang. It was all about proportionality and what the test is for justifying interference. But I don't want to distract you yet further because, as you say, you've got to finish.
I have got to finish. Huang was as much about the existence of family life as Betts was. It was en route to the decision as to. So what Lord Justice Bingham was saying at that stage in Huang from memory is, what does the tribunal have to do? It has to make a finding as to whether there is family life. What does that mean? What does family life mean? This is what it means. It's en route to the conclusion. Yeah. And that's what I have to balance against what's the tribunal got to do? It's got to make its findings of fact about that. The Huang was about the function of the tribunal, wasn't it? So what's the tribunal got to do? It's got to make those findings. And what has it got to make findings about? It's got to make findings about family life. So my submission is it's a passage which is frequently quoted. No doubt approved in authorities that I'm not going to be able to pull out of the air usefully for you. But I would, at the very least, it's very strongly persuasive authority as to what amounts to a family, and therefore what the way in which you should read down elements of dependency. The consequence otherwise is going to be that family life, if you can put 2 people in different countries, they won't have family life. And that would be inconsistent with what Lady Justice Arden says, and it wouldn't. The other paragraphs that I wanted to refer you to for the question of whether there is family life are the summary of Kevin Perkins' evidence on page 103 through to 104 of the core bundle. And particularly paragraphs 48 and 49. Also 50, I think I've taken you to those already. There is, then in the core bundle, the annexes to the First-tier Tribunal's decision, page 115, paragraphs 15 to 18, this is the appellant's sister. It's her expression of the dependence which we say exists between the family members, and then finally Dr. Galapathi's evidence in the supplementary bundle, page 192. Pages 90, sorry, page 192, paragraphs 92 to 94.
Sorry, which page?
192,
Paragraphs.
92 and 94.
Thank you.
So if he continues to be separated from his family, he's likely to suffer from further deterioration.
So as you say, given Mr. Malik's wish to reply, what do you now need to cover?
So I need to cover ground 2. I need to cover ground 2 and ground 3. Ground 2, what's the correct test which should be applied when you're looking at whether the First-tier Tribunal has erred in law? Can I ask you to look up REW? It's one of the authorities that I have, that were handed up earlier on today. So REW, again, certainly my Lord Justice Baker will be extremely familiar with all of this history. This is one of the cases that comes after RE-BS,
Yes.
on the test for applications to oppose adoption orders was amended and relaxed on one view. The court in REW looked at cases which had been decided before BS and therefore had been decided by reference to the wrong test. What was the way of looking at those judgments? And the answer, we say, is in paragraph 16 of REW. You're looking at a decision where, through no fault of their own, a judge has applied the wrong law, 16. The Court of Appeal must have regard to and make appropriate allowance for that fact. The focus must be on substance rather than form. You don't knock something out just because it gives the wrong test. Can it be said on a fair reading? Did the judge's approach engage with the essence? Can it be said on a fair reading of the judgment as a whole? The judge has directed his mind to, or her mind to, and provided answers to the key questions. But there's a broad reading. Don't knock something out just because it doesn't apply the test which it should have done. The Upper Tribunal's error of law decision, so that's in the core bundle. I've already taken you to some of the evidence which was before it, at paragraph 63 and 64. Sorry, no, it's pages 63 and 64. No, sorry, it is paragraph 63 and 64. That's material which was before it, the First-tier Tribunal, the Upper Tribunal, when it reached its original conclusion that there must be family life. It then returned to that question. You've already been taken to this, and I don't have time to take you back through the error of law hearing, but of course, Ms. Malik's right that the Tribunal concluded the error of law hearing by finding family life. Importantly, it returned to that question in the remaking decision, and you see that starting on page 88 of the core bundle, and at page 90, paragraph 29, you see the tribunal, the Upper Tribunal, returning with an open mind to the question of family life in light of Kamari and Alvarado. And I'd invite you to read the whole of that section. My learned friend takes issue with the first half of paragraph 33 because Upper Tribunal Judge Bruce thinks that Kamari and Alvarado are not going to result in a loss of the real, effective and committed support test. She's wrong about that. I accept that. But it's crucial that she then goes on to make the finding in the alternative. And my submission is nothing at all unclear about what she does. She says, I don't read those cases as requiring that someone is left entirely incapacitated. So in other words, I don't read either of those cases as meaning that that exclusive or absolute dependency is necessary. But if I was wrong about it, I would find that there is exclusive dependency. And why does she conclude that? It's the extraordinary degree in which the sponsor has come to focus his attention on the plight of his family. And that's key to understanding his inability to overcome the severe mental illness that currently impairs every aspect of his life. That's his dependency on his family. He's dependent on being in contact with them, being able to know. There's evidence that you will see and that you've seen that every morning the first thing he does is wakes up and rings them, check they're still okay. He's dependent on that constant news from them, that they're still alive and they're still okay, because that's what is enabling him to function at all. And so I've addressed the 2 points. My learned friend, firstly, we say that the Upper Tribunal has applied a test in the alternative more favourable to the Secretary of State than the test which it was required to, and secondly, there's nothing perverse about its conclusion. My learned friend, the ECO doesn't have permission to argue perversity, but in any way, there's no merit to it. My lords, there are 2 points taken in paragraphs 29 and 31 of my learned friend's skeleton argument. There's nothing, I think I've dealt with those as matters of law already. They raise points which go to proportionality, not to the existence of family life, and in any event, my learned friend hasn't established that the tribunal fell into those errors. So I'm going to move on to ground 3, and otherwise rely on the skeleton argument for ground 2. When you're reading the remaking decision, and particularly proportionality, please look at the very last paragraph, because that makes clear the extent to which the tribunal was aware of the weight that had to be attached to immigration control, and it concludes by addressing the test of unjustifiable harshness, which is the very test that Lord Reed set down in Agyarko when the tribunal is considering applications which are outside the law. You've already been taken. I've already referred you to the fact that the Upper Tribunal directs itself in accordance with a published policy. That published policy is set out in full in its judgment, and it answers the question whether there is any policy which might cover people in the appellants or in the respondent's circumstances. You find that on pages 92 to 93 of the core bundle, and it refers in particular to sponsors who've exhausted all treatment options, and that the medical condition of the sponsor can only be improved by the applicant joining the sponsor in the UK. So it's page 93, second paragraph that starts, if the sponsor has severe. The medical condition of the sponsor can only be improved by the applicant joining the sponsor in the UK. That's exactly the evidence we said, that's the unchallenged evidence which is before the Upper Tribunal in this case.
Sorry, why is that policy not satisfied here?
Well, we don't say it's not satisfied.
Well, then why do you need Article 8 if you qualify under the policy?
Well, in order to succeed on any appeal to the First-tier Tribunal, you have to succeed on Article 8 grounds. The Tribunal has no jurisdiction to do anything else. But we do say that policy covers us. I mean, it certainly fills the gap. It certainly provides the basis upon which the Tribunal could balance could conduct a balancing exercise differently, and which is that was the issue in IA and others. My lords, on page 90, I'm going to one sentence about each paragraph. Page 94, paragraph 40. None of the appellants and sponsor chose to be separated. But what my learned friend says is that there's too much focus on the respondents here, and we say if you look at this whole section from 40 onwards, that's simply not right. Firstly, the heart of the appeal says that the Upper Tribunal in paragraph 43 is the dilemma facing the sponsor, and the sponsor's circumstances are plainly at the core of the Upper Tribunal's consideration of this appeal, and you see that from paragraph 43. The heart of this appeal is 8 lines down into paragraph 43. That's what IA and others, this court and IA and others said should be done. It's really difficult if the Upper Tribunal considered that to be at the heart of its appeal. It can't be said that it just puts too much weight on other issues. But in any event, paragraph 40 is not primarily about the circumstances of the appellant, the respondents outside the UK. It's about the circumstances in which the family came to be separated. And my learned friend says that that's one of the factors which was relevant to the weight to be attached to family life. This is not a family who are separated by choice. Paragraph 40 is plainly correct finding. It's not a finding about the hardship facing the sponsors. Paragraph 41, current circumstances. I've already shown you that the Court of Appeal, NI and others treated current circumstances as being a relevant consideration. There was nothing wrong with the Upper Tribunal doing the same. 42, best interest of children. That is a relevant consideration. It would have been a material error of law if the Upper Tribunal had not included paragraph 42. There's nothing wrong with it having done it. And then all the way through 44 to 46 is about the circumstances of the sponsor. That's the focus on the family member in the UK. It's what I and others says that the Upper Tribunal should have done it and did it perfectly correctly. 47, it's a point made that this is not a case in which there's a choice about whether family members can live. The tribunal can't be possibly criticised for having drawn attention to that fact and taken it into account. And then finally, considering all of these cumulatively and given due weight to the public interest, including the strong public interest in the maintenance of immigration control, it really is nitpicking to criticise the Upper Tribunal for not having used a particular formal words, which is, you can assume that the Upper Tribunal knows when it says the strong public interest in immigration control, that's what it means. And so there's nothing to the, if we succeed in resisting the Secretary of State's grounds 1 and 2, there's absolutely nothing wrong with the proportionality. My Lords, I've already taken you to the evidence that I'd rely on in showing that family life existed, and you've heard why I would submit that you shouldn't be conducting that exercise, and that there should be findings of fact about circumstances as they have changed significantly since this was ever before a tribunal. Thank you for your patience. Those are my
Just check there's nothing else to do.
Sorry.
Thank you very much. That's really good. Mr. Malik.
Lords, Millennium Friend took you to several authorities in his opening submissions. All of those authorities, apart from Ali, were considered in IA and others. And in my respective submission, it's IA and others where the focus should be. Lord Justice Singh asked a question when Millennium Friend was making submissions as to how the appropriate weight phrase used by Lord Bingham in Huang was converted to very significant or very substantial weight, as is the phrase that is used in IA and others. The answer is behind tab 3 of the authorities bundle. Following Huang, the Secretary of State has made Article 8 rules. Has made Article 8 rules.
Yeah.
These rules were not in place when Huang was decided. And if you look at the text, you'll see that the rules essentially are the Secretary of State's implementation of Article 8 into the immigration rules. They strike the balance when it comes to the question of proportionality.
Sorry, where are we looking at? The FM?
Yes, Appendix FM, yes, indeed.
Thank you.
Tab 3 of the authority. And these are the rules that reflect public interest considerations in the 2002 Act and indeed Section 55 of the 2009 Act. So in presence of those rules, IA has used the word very significant or substantial weight. Millennium Friend points to an apparent tension between paragraphs 1 to 5 and 1 to 8 of IA and others. Lord Justice Singh observed that it wasn't entirely easy to reconcile those two paragraphs. In my perspective submission, there isn't a tension. And I do ask you, Lords, to look at paragraph 132 in the event you feel that there is a tension. That paragraph makes it absolutely clear that real, effective and committed support is relevant, but it is not conclusive, it's not determinative. second last sentence of paragraph 132. The assessment of whether there are additional elements of dependency in my submission is an objective assessment rather than a subjective assessment. Miller and Friends says that paragraphs 79 and 80 of the First-tier Tribunal's decision are the core of that decision, and it is those two paragraphs that Miller and Friends seeks to impugn.
Sorry, which paragraph?
Paragraphs 79 and 80.
Yeah.
So these are the two paragraphs, and you have competing submissions as to whether the judge there was simply referring to manifestation of contact or something more. But may I ask you, my lords, respectfully, to see how paragraph 79 starts? I do not accept the extent of contact amounts to emotional support. So in that paragraph and in the next paragraph, the judge was addressing a particular submission about the contact that was made on behalf of the respondents. And if you wish to see where that submission is recorded, it is at paragraph 61 in the final sentence, last two sentences. You will see that the respondent, last two sentences of paragraph 61, referred to the evidence of contact and made a submission that showed that the sponsor and the respondents are in daily contact with each other, and the photographs show a family which was gathered together manifesting more than ordinary emotional ties. And the judge was simply responding to that submission in my submission at paragraph 79 to 80. And it would be, in my submission, wrong to simply pick one sentence from that paragraph and subject it to narrow textual analysis that this court has said is not appropriate. On the question of proportionality under Article 8, Miller and Friends says that there is a policy, unlike I and others, and the policy is quoted in the Upper Tribunal's decision. And my Lord Justice Singh asked, well, if there is a policy and if you meet the policy, then what's the point? The answer, my Lord, is that if you look at the policy, that isn't a policy that concerns grant of leave to enter or remain under a particular category. Page 92 of the bundle. This is the guidance to the caseworkers as to how to assess exceptional circumstances under Article 8. It's nothing more than that. It says that in assessing exceptional circumstances under Article 8, you must take into account certain factors. That is it. The Secretary of State's policy is set out in the immigration rules in Appendix FM. If the requirements of that policy, that rule, those rules are not met, then a person may succeed only by showing very compelling or exceptional circumstances. Judge Bruce has identified no such circumstances in her decision, nor did she apply the correct test. Lord, on the question of disposal, you have heard submissions from both sides. But may I simply pick on one particular submission that Miller and Friend makes, which is that it would be appropriate for this court to remit the case to Judge Bruce. Well, I do ask you, my lords, to set aside the decision made by Judge Bruce, find that there is no material error of law in the First-tier Tribunal's decision, so that decision stands. But if you are not with me, and if you take the view that a remittal is inevitable, then I do ask you to consider respectfully whether it is appropriate for this case to go back to Judge Bruce who has already said that there is no possibility of a different outcome. The only rational conclusion open to any judge, he says, is that Article 8 is engaged. Lords, I'm very grateful. These are my submissions in reply.
My Lords, I'm so sorry, there was one thing I didn't address you on. If you were remitting back and not to Judge Bruce, then we would be saying it would be more appropriate for it to go back to the First-tier Tribunal, because I think I can't remember whether I said that. I think I might have said that I needed to take instructions on it, and those are my instructions. Sorry.
What do you say about that?
Lord, yes, I have no objection to that, my Lord, if you take the view that remittal is inevitable. Yes. But I do ask you, when you come to write your decisions, to look at Section 14 of the 2007 Act. You'll find a way to address the issue that is troubling you in the event you decide that there is something in grounds 1 and 2.
No, I don't detect any more questions. So thank you both very much for very helpful submissions. Thank you to Ms. Turnbull and others behind you for their contributions. As you'd anticipate, we're not going to give judgment here and now. You will receive the judgments in due course electronically for you to point out our errors of typing and English. That won't, of course, be an opportunity to re-argue the case. We'd be grateful if at the same time you would seek to agree an order dealing with consequential matters. If there are points on which you can't agree, can we please have brief written submissions, and we'd expect to settle the points in the order that we make. Lastly, although it will be well known to you, I will just remind you of the importance attached to the embargo which will come with the judgment. Breaches of it are still occurring. They are taken seriously. If you think of anybody who we don't already know about who ought to see the judgment in draft, you obviously need to come back to us. But thank you again.
All right,